Kim, here we are. We're on the bench.
I know it's going to hurt my neck though, looking at you like this.
Is it?
I want us to keep looking that way.
Well, there you go. But when we did the one from Mount Buller, and here's thumbs up to Mount Buller, that was a lot of fun. I think it was much easier for Nina and I to talk here than from the other side of the room. So we thought we'd give it a shot again and see how you think. Makes me look a bit chubby, I've got to tell you.
I feel a bit thin.
Yeah, no, but at the yours very thin. Anyway, so look, today we're going to talk about overseas employees, but we're not going to come to that straight away. It's a strange time during recessions, and it really is a recession at the moment, isn't it?
Yeah, we're feeling it.
Yeah, everyone's feeling it at the moment, isn't it? And it's one of those things we need to be aware of, that people are going to hold on to issues and try and fix them. And when they blow up, when they've got a shit sandwich, they're going to go, what do I do with it? So can I just remind you, if issues are blowing up, you can talk to Kim for free. You can just say, hey, Kim, what's this happening? Sometimes that early moment of guidance can save a lot of problems. Yeah. But what we do see during these difficult times is we don't suffer financially because we get the shocking files. What we don't get at times is people coming to us when they have a problem because money's tight. Yeah. So can you just use the free service first, which is, Kim, have you got 3 minutes? Or Andrew, please don't sit on something that's complex and then give it to us with sort of sad looks on your face and say, oh my God, this has gone wrong. But we're feeling it for you clients. We really do get it. I thought we might talk about the first major case, is the psychosocial prosecution case. This is an absolutely fascinating case. It's interesting, in WA, there's been a genuine reluctance by the regulator over there to engage, particularly in individual prosecutions. Okay, so there's been an openness to talk about it, but not a lot has been done. But what's happened here? Tell me.
We had a improvement notice that was issued against the Department of Justice, ironically.
and can I just say, this is when they start prosecuting novel things, they always start prosecuting government. I don't know why it is, but it's always, this was a prison, wasn't it?
Yes, it was. And there had been complaints about bullying, victimisation, sexual harassment that hadn't been addressed or eliminated, so they received an improvement notice over that. They failed to comply with the improvement notice, so therefore they got charged.
Yeah. Now, can I just say, here's the warning sign. Regulators now, in every jurisdiction, have specialised people who are dealing with psychological hazards. Their method of gaining entry means they're going to give you an entry notice, but likely they're going to look at your documented processes and your complaints that have been made, and from that will be generated an improvement notice. Improvement notice for psychological hazard is actually hard to comply with. Okay? We can give you copies of the types of improvement notices that are, or the entry notices that have been given, because they're very similar throughout Australia at the moment. But what I want you to understand is policy doesn't fix problems, it assists in controlling them. It's actually the elimination of it that's the key issue. And that requires direct action. So, look, interesting start, you know.
I know from speaking to a client last week that WorkSafe in Victoria are really targeting the motor dealer industry at the moment. So just be aware. Have you good processes in place?
And they're also dealing with entertainment. And they're starting to deal with schools. So they're looking at particular industry groups where there are high risks involved, and they're coming and attending. Personal breach of safety. Kim, this really is a big issue, because this is the 5th prosecution in 4 months that I'm aware of for an individual using motorised plant, forklift cranes, that type of apparatus, where they've failed to provide a safe exclusion area and harmed somebody. And so from that, and the facts are uncontentious in this case, he reversed into a co-worker and did really serious, both physical and eventually psychological injury. But what's important about this is, what are the 3 major hazards that are or are about to be prosecuted? They're working from heights, motorised plant, so I've got 3 fingers up already, and psychological hazards. So are individuals going to be prosecuted when that occurs? Absolutely. And that means a driver of motorised plant. That means a worker doing something bad to others. We saw a criminal prosecution of somebody harassing an apprentice in Ballarat, not an OHS prosecution, an actual criminal prosecution. So we're starting to see regulators, including the police, say, if you harm someone and there is a known control and you don't do it, it doesn't matter about the failure inside the organisation, we're coming after you. Is that a good thing? Oh, I think it is actually. But what it says to employers is they've actually got an extra tool in their toolkit.
Yeah.
They can say, hey, Kim, you drive this plant. Be aware you can be prosecuted. So please stick to our rules around exclusion. Yeah. Okay. And Kim can say, look, I'm liable for this. I really need you guys to stop walking in my area, and I need some support to make sure it's excluded. Yeah. So I think it's really thrown a bone to both employers and employees on how to manage high risk activities. Yeah. So I think it's good. It is good. But be aware it's happening at a high speed. Anti-vaxxers.
Now look, we're not letting them go, are we?
We're not. I just can't let it go. So these were two HSRs, health and safety representatives in government, who refused to comply with a public order and said there wasn't adequate consultation and continued to refuse to comply. They were sacked. It's very sad. But they argued in a general protection sense that it was a protected right, that there was a failure to consult. And you'll be stunned to know that the court said, actually, it's a public order. Consultation in safety terms is not a requisite. You were sacked because you refused to comply, not because of the absence of consultation, and goodbye. Yes. Okay? Sure. Very simple case. Now, will that apply in everything that occurs? Public orders have a life of their own, can I say? If an HSR came to you and said, look, you had a notice of entry, it tells us we've got to do these changes. That's not a public order. The way you then undertake that safety review and execute remains, despite being given an entry notice, a level of discretion as to how you would manage that and the necessary assessment process. So at that stage, the law says you must consult. And if you refuse to consult and the safety person says, we can't support that, you couldn't sack them. But if the safety person then refuses to do it but doesn't go under the regs and say, well, we're in conflict, let's get in work safe, but literally stops you from being safe, at that state you can sack them. Okay? So interesting stuff. And remember, under safety legislation, there's anti-discrimination legislation. So when you're dealing with someone who's creating that risk for you and they won't let you be safe, and the methods by which they require safety are onerous, unrealistic, unreasonable, you're allowed to have that discussion. But my view is at that stage, call in WorkSafe, because you've got conflict and they actually help with that stuff. And at that level, they won't prescribe unreasonable outcomes. Once they come in and give a notice, that's when you've got a bit of a risk. But actually trying to resolve conflict, they're not too bad at it. Okay? Risk assessments and failure.
Oh, this is another one. Oh, no, hang on. I've missed one.
Have I? I've missed one? What have I got?
No, I have.
Yeah.
I have.
We act for a lot of schools, and when we look at our group, there's probably 30 across our group, and in the last year this is the third incident where a child has lost their life because of a flawed process. In this case, it was a New Zealand case, so it's not an Australian case, and it deals with kids going into an environment where there was high risk created if there were heavy rains.
Cave exploring.
Yeah. The Bureau of Meteorology over there said it's orange warning, which means very heavy rains. The risk assessment didn't define what heavy rains were, and there was inadequate communication as to the level of risk that attached to rain to caving. A child died, drowned. It's an incredibly sad story, but what it sheets home is this. When you do a risk assessment, your job is to identify the nature of the hazard. I'm in an environment where heavy rain could cause flooding. Okay, hazard. What is the level of risk? It is extreme. Therefore, the nature of the control must be calibrated by the best evidence as to what is the nature of the risk arising and how can it be safely managed. So having ambiguous titles like heavy rain don't assist. Now, I think we've done probably 6 or 7 outward bound issues for schools over the last year, at least I have. Kim doesn't do that, I do it. And each time as I look at the risk assessment, I go, generic. The nature of the risk, the highlighted risk, whether it's surfing, whether it's whatever, doesn't take into consideration children do inherently dangerous things. The circumstances of nature are unpredictable, and therefore there must be a predictable description of risk that everybody understands where the word no follows. At that stage, this arises everybody out. This didn't happen. So what's happened here is there's a bit of a tick and a flick. Nobody quite got how dangerous it was, which is the case with most major high consequence hazards. Not high frequency, because high frequency people get, I'm going to trip over that, it's terrible, don't do it. But ones which are high consequence can happen. They're once in a season type things. People are a bit oblivious, and the other part is everyone goes, no, we can do this, we'll be okay. You're not. So look at high consequence, get the data right, calibrate the risk assessment right, and make sure people are competent in that risk assessment. Otherwise, like this case, we're ordered to pay reparations of over $450,000. It's not surprising. It's pretty bad. That was the school board who copped that. Okay. Now, slightly different system, very similar WHS system to Australia, but the methods of awards of damages and fines is a bit different. A refreshing case.
I like this one.
Okay, so this is a case of a woman who was sacked for sexually harassing. She had to fly from, was it from
She was flying from Brisbane to WA. She was a mine worker. She was drunk when she got to the airport. Was very hands-on, one of her male colleagues.
Rubbing against them.
Yeah. Rubbing, that's right. Rubbing her body against him. And then on the aeroplane, putting her lap in her other work colleague's lap.
Her head.
What did I say?
Put a lap in her lap.
Oh, sorry.
That was
put her
a
head
step
in his
too
lap.
far, wasn't it?
He felt very uncomfortable. Anyway, obviously touching him, all that sort of thing. So they stood her down, investigated, terminated her, found that she had harassed the first one, sexually harassed the second, and she brought an unfair dismissal claim.
Yeah. So can I just? We don't often see it the other way around, if that makes sense. So about once every 2 or 3 years, I'd get a sexual harassment where a woman's been alleged to sexually harass. People usually giggle about it rather than face the truth of what it is, which is it's just unacceptable behaviour. But her argument in this case was not that she didn't do it.
It was out of hours conduct.
But that it was out of hours conduct.
Yeah.
And that brings in Rose and Telstra with the 3 tests that apply in Rose and Telstra. But one of the key tests in Rose and Telstra is if I do something to Kim when I'm out and I can't then come to work the next day, which is Heath's case. Heath's case was in an Aboriginal health organisation, a guy who taught young men not to physically assault women and to avoid violence, and beat up his partner and was locked up overnight. And they said, look, you can't come back. Heath could never have argued in that case, but I could work with a different group of people.
No.
In this case, it's not for the organisation to adjust, and this is what she argued, well, I can go and work somewhere else, not with these people.
Yeah.
That's not the test in Rose and Telstra. The test in Rose and Telstra is, have you done damage to the relationship between employee and employer? It's not the employer's obligation to make change as a result of the employer misconduct. So here, what she did was fatal because she could not be reintroduced to work with these people safely.
Yeah.
So I think a fascinating case. All right, unreasonable hours.
Okay.
I think for me, this story sort of resonates because post-COVID it is a common complaint that people now working flexibly work all sorts of hours. They actually choose those hours, which under an award, can I say, is not good because awards describe hours which are ordinary hours of work. And so we've had a number of issues where people working outside of hours subsequently come back and challenge that they worked outside of whatever the ordinary hours were contained in the award and therefore required overtime. Are people picking the red flags as I'm talking? Because we allow this to happen all the time. We've given people a level of discretion around how they work, but when things go wrong, they weaponise that and bring it back to us. In this case, it was a product manager who said they'd worked extraordinary hours. They was requested by management to do them. The timelines to do things were unreasonable. They produced some documentation around it. And the judge, who was a fairly worldly judge, said, this is the section 62, should I say, of NAS, which talks about what are reasonable hours. And reasonable hours are hours that look at the nature of the work that you undertake, your personal circumstances, and say, look, what is reasonable? And that's an objective test. What this person said is they were unreasonable. And the court said, well, there's 2 things you're going to have to prove if you come here. One is you were requested to work those hours, or the request to get a job done required you to work those hours at that time. And you're unable to provide either of those. And it provides some quite good guidance generally. But I guess the reason I put this one in is this post-COVID flexibility that we have sounds great. But with award-based employees particularly, I want you to know it's not great, okay? That there are hours defined by awards that say what work is. And the other part is good people work hard, and without guidance, they will work repeatedly hard. Now, will they be able to bring a claim under Section 62? Not unless they've documented it very carefully.
Yeah.
But angry people do document. Okay, so they send you an email, say, do you really want this by tomorrow? And you go, yes, that's the request. And if the work is 20 hours worth of work, then you're dead.
Yeah.
Okay,
Yeah.
so an interesting case because it's one of those cases of an era. It reminds us of all the other risks that sit around reasonable hours, which includes award breach. Okay, anyway, look, that's why I stuck it in. Isn't this a fun case? Restraint cases, we deal with restraints probably weekly and breaches. Restraints are hard to enforce, okay? And there's a case law that says if it's only, it must be to protect the goodwill of the organisation in a defined and clear way that is reasonable in the circumstance. It can't prevent a person from working. That's a very, very short version of the law in Australia. But this was a person who left an insurance group, and there was a quite significant move of clients, and the person, like a snail, left a trail on their mobile, the mobile phone they didn't run over, the mobile phone they didn't drop in the water immediately before discovery, after the discovery order. Can I say, if you destroy a phone when a discovery order is made, you are dead. Anyway.
As it was in this case.
Yes, it was in this case. Yeah. But there was evidence of messages that were sent that sat on their system to clients saying where they were going. There's a $500,000 order in this, which is an account of profits. This is the loss that has been suffered, okay? But what I want you to know as an employer, because our job's employers, is when someone says they're going to leave and they hold goodwill, in other words, they're a salesperson who has a generalised history, they're a senior lawyer who acts for clients which have been transferred to them, it is not wrong for you to have a look at what's on their internet system and on their phone. In fact, it would be foolish not to do it. And then to check from time to time, look at deleted messages, look at messages that have been sent home, look at the document management system to see what's been taken away, whether client lists and contacts. Am I being suspicious and stupid? No, I'm sorry, I'm an old guy and I just see it all the time. So the hardest part in a restraint case is proving the breach.
See, in this case, it was interesting because it was a lot of circumstantial evidence, and we always talk about you need to prove absolute breach. So I was heartened by this, actually. That, you know, an employee ringing the client and making a diary note of what they told them was accepted as evidence of the breach. Yeah,
and look, it was, but what triggered this? Well, there's two things that courts are human, so there's two things that triggered it. One is there was deliberate evidence of the sending of messages to people, so that's hard evidence. And some of those clients were lost. Okay. Secondly, there was the phone destruction behaviour. And when you deliberately destroy documents, beside it being a criminal offence to destroy documents that are part of civil proceedings in every jurisdiction under Crimes Act, so people don't know that, but it's true. It also is an absolute indicator of dishonesty. And there's some cases around dishonesty, both in criminal and civil matters, where there's no other reasonable explanation for running over a phone with a lawnmower and dropping it in the ocean after a discovery application. I don't think anyone believes that. Anyway, fun case, but I think heartening for business. But remember, business, there's things you just got to do. You mightn't like doing them, but they're critical. Why don't we go to the next one? Because I think this is the big one, isn't it?
This is the big one.
Right, I want to say about this case. This is a case about an overseas employee. It was a woman who was employed by a legal practice. She was employed in the Philippines as an independent contractor. She did paralegal duties. She was, on any objective evidence that comes through the case, she wasn't treated wonderfully as she went and was eventually terminated, and she brought a claim. Unfair dismissal claim. And what we had was a jurisdictional claim as to whether
she was an employee.
As to whether she was an employee. So the key issue here is, was she an employee? And for the purpose of the jurisdictional argument, she walked, talked and looked like an employee. Since the High Court's been crushed as far as legislation goes, the traditional test applies. What was the nature of the work? What was the level of control?
Did she have the right to delegate?
Yeah, all those things. Clearly she was an employee. but there is obiter. That's a legal expression for not final determination around jurisdiction, and I think that's flawed. Can I just get that out there right now? Where they said that a person who is a resident in a foreign jurisdiction but is an employee of an Australian constitutional company has rights around unfair dismissal, I don't think is right. But we'll have to wait and see. It will be agitated in the final hearing, this matter. This matter was settled, so it will never go to the next stage. And the obiter remarks, these remarks that have been made, I don't think they're right, but we don't have a case that sits there that tells us what it is. So it is a red flag to employers when they run this model, independent contractors without the appropriate structure. Not a good idea. And this is our main topic for today, really, we're talking about. In every country, there are now organisations that you can engage people through an intermediary to make sure that the foreign law around safety, workers' compensation, all those issues does apply, and therefore they are you can exclude the risk here, except in places like France and stuff where there are more onerous obligations than Australia. Australia has one of the most onerous sets of obligations, and we have an award system that no one else has. Okay. So there are simple ways through this. If they're a genuine independent contractor, get the independent contractor contract right, but for a little bit of extra money. Remember, you're not paying much. And here, this woman, if she wins everything. She wins award payment rates, and she was paid considerably
under the award.
Under the award. Why would you do any of this when you can hire through an independent organisation overseas this person directly to them, not you, and you have no risk? Now, why would you do it? Particularly when it is a problem that exists in different organisations, in different countries throughout the world around what is an independent contractor employee, and these purpose-built organisations are now international who do just that for you, and for whom you can still control what is being done without the risks of it being a direct employer, like a labour hire. So there are ways through this stuff, okay? You don't have to take the high risk way. And remember, cheap always comes at a bigger price, okay? And the biggest price for all of us is risk. Well, that's major topic done and dusted. So why don't we get onto the case study? Now, here we go. You're the reader. Do you want me to read the case study?
No, I'll read it.
You don't feel awkward reading it?
No, I do. I've got Invisalign. Don't do it. It's not worth it.
Well, I think she's just caused another piece of litigation against us.
Oh, shit.
And now another one for saying shit. I don't mind reading.
No, I could read. It just hurts.
I don't notice it, but I know you feel it.
Nigel was concerned about the independent contractors engaged by
Nostradam
Leaning Proprietary Limited, or NL.
That should be learning, by the way. That's my spelling. Nobody fixed it. But anyway, Nostradam Learning.
Okay.
So you can learn from that incredible character about what the future's going to be. Nostradamus.
Oh, okay.
Yeah, no, it's just bullshit I do when I'm
talking. There were contractors throughout Asia, being residents of Asia and Australia. Their role was to assess safety exams for Cert 4 safety at institutes for advanced learning in Australia. I've really got my list.
Yeah, but it's going well. I'm liking it.
Nigel had received 2 letters that alarmed him. One was from Prasad in India, arguing that his termination was unfair under the Fair Work Act and that he had been underpaid. His rate in India was $9 per hour, which was below the award rate. Prasad was hired as an independent contractor. He stated that he had been injured at work and was seeking workers' compensation. The second letter was from Ken, a resident of Sydney, who had always worked for NL as an independent contractor. He claimed he was owed superannuation, holiday pay, loading and overtime, as the work was done on piece rates not recognised by the award. He forwarded a spreadsheet detailing the hours worked. He also complained about the lack of resources that had led him to developing RSI. He made a claim based on the Victorian Certificate of Capacity he had sent to his local doctor. Nigel advised Ken he was an independent contractor and needed to insure himself. The Victorian Workers' Compensation agent rejected both claims. So, was the Victorian Workers' Compensation agent right to reject the claim? I would say yes.
Absolutely. Yeah.
But Ken would have had a claim in New South Wales.
That's right.
And so NL would have had to have taken out a policy in New South Wales.
And that's a real problem for NL because otherwise the statutory obligations that arise hit them very heavily.
Yeah.
Okay. So can I just be clear about that? When you're a resident outside of Victoria, or if it's in New South Wales is the site of the business, outside of New South Wales, wherever, the law of that jurisdiction holds what is workers' compensation. But your obligation as an employer is when you employ somebody outside of a jurisdiction is to be ensured they are covered by the relevant jurisdictional workers' compensation to the extent that it is required. So in India, it's not required.
No.
Okay. So it's not understood, but what I do want to say to you, you can be prosecuted, and that prosecution in New South Wales is not a nice prosecution, and the premium cost hit after that is just massive.
Yeah.
So please, it's very common to have independent contractors. It's very common to have them in different jurisdictions. Independent standalone contractors are deemed employees in every jurisdiction for the purpose of workers' compensation.
Yeah.
Okay, so for those of you who want to puddle through Clause 9 of Schedule 1 of Victorian 1, you'll find it, but you'll find the same throughout Australia.
Yeah.
Okay.
Well, you've answered number 2.
Did I?
Yeah. Was NL liable for Prasad's work cover claim? No, he was not, because he was a resident overseas.
Very good. Could Prasad bring an unfair dismissal claim in Australia? What would he need to prove? Could he bring a claim for an award breach and underpayment? Now, I've told you I don't know the answer to this. And I think the case that we've told you about, I'm not sure it's right. But let's assume for a second that the discussion that arose in the jurisdictional hearing is right by the judge. So let's assume you could be. At that stage, once the jurisdiction applies, the award does apply. It's pretty horrible, isn't it, after that stage? And there is absolutely no doubt that Prasad and these people are being directed to do a job. Now, the issue is what level of control they actually have. Can I work whenever I feel like? Can I get someone else to do the work for me? That's going to be a question of fact going through it. But any standalone, alone ABN type person, without an incorporated entity, without other people working for them, without a capacity to truly delegate, and here you would assume that Prasad has been tested to be able to be competent to do it. It's hard for him to delegate. At that stage, if he can bring a claim in Australia, you're in deep shit, because I think he's definitely going to be deemed to be an employer. And I think the thing we're seeing in the Fair Work Commission at the moment, which is different, is that it doesn't matter where the commissioners come from, what political background they are, they're moving quickly to see that anybody who fits the traditional test of what is an employee, they're very quick to go there. So that's a problem. We've got another question. I'm sure I read another one.
Yeah, a couple more.
Could Ken bring a claim for a breach of award and underpayment? Now, remember, he was in New South Wales. What would he need to prove? I don't think Ken has any trouble in bringing his claim.
No.
Okay. Piecework is only set out in a number of awards. So if you're paying someone to do something based on piecework, beware, because hourly rates apply. And if Ken can demonstrate a requirement to do work and a permission to do it as and when he feels it, then the award breach is highly complex and difficult to establish. Well, was it out of hours? Was he entitled to overtime? Probably will struggle around those issues, but he'll certainly be entitled for all the entitlements that flow from it. But what I do want to say is this. We haven't talked about this. We've both been a bit shy about it. But the reality is, I don't want anyone to forget that if you're on a non-delegable independent contractor, in other words, I can't get someone else to do it, and you're only working for one person, and we'll come back to workers' comp in the 80% rule, by the way. We forgot to talk about that. Then you're probably obliged to pay superannuation as well. And I want you to remember, with superannuation, there is no limitation period for the recovery of that. Okay, so underpayments there are. Now, as Kim will always say, you're only obliged to keep records for 5 years, and these cases always turn on records. So there is a practical thing that may prevent it to a degree. But courts are happy to jump in and have a guess based on what you're being paid, what your entitlement would be. But we should have said about the workers' comp, and it was my fault, that irrespective as a contractor, if what you do is 50% of your work is only done for the organisation, you're using assets. you're definitely not going to be a deemed independent contractor. But if 80% of your work and remuneration is purely labour, then you're a deemed contractor, a deemed employee. Okay. Yeah. Now, is there a better way to manage local and overseas workers? Well, we've just talked about it before. One, if you're going to use independent contractors, set up the process correctly, get the right contracts. But why wouldn't you use a shared service provider overseas to engage these people so all these risks just disappear? That's what we've been doing recently with a number of professional services business. We were seeing people in New Zealand and other places where we go, why would we get caught up in this? Why wouldn't we have somebody who's got a skilled HR part who manages all that process? We don't do it.
Yeah.
We just direct the work that we want done. That's my suggestion anyway. And remember, employees and contractors, the tension is growing. And more quickly, every day, regulators and tribunals, commissions are going, no, look, if it looks like an employee, you're going to be an employee. So be careful.
Yeah.
Thanks, Kip. Lovely to have you on board.
Yeah.
I didn't hear the list.
Oh.
Okay. We've known each other a long time. I lie easily. Anyway, thank you very much for being here. We're back at home and see you next week. Cheers.
See you.